Mutcherson, co-dean of Rutgers Law School in Camden, and this is The Power of Attorney. For our segment today, I am lucky enough to have with me Professor Katie Eyer from Rutgers Law School on the Camden campus, someone who I've been able to work with for quite some time now and who's a fantastic person and an amazing scholar. And so I'm really excited to have a conversation with her today, both about how she ended up at Rutgers Law School, but also about some of the things going on in the world today that are incredibly important. So Katie, thank you so much for joining us.
I am delighted to be here, delighted to join one of my favorite deans and colleagues. So I'm excited to speak with you here on the podcast.
Thanks. So, what I always like to do in the beginning of these podcasts is I ask people for their origin story, right? So, how is it that of all the things that you could have done in the world, you decided that you wanted to get a law degree and then made the extremely odd decision that you wanted to be a legal academic?
So the path was definitely long and winding. Indeed, at some point, in my adult life, I went back and found a letter that I had written to a friend in college saying, God, I hope I don't become a lawyer. So I did not expect to wind up here, but I happened to take a class on constitutional law in my undergraduate education. And in that class, we read the case of Bowers versus Hardwick. Many lawyers may be familiar with that decision. For those who aren't, it was a case in which the Supreme Court rejected the idea that there was a constitutional right to engage in same-sex intimacy and said the state could criminalize same-sex intimacy. But what truly offended me about the opinion was it was sort of gratuitously anti-gay and went to great lengths to make clear that the justices thought that there was no connection between same-sex intimacy and ideas of family or marriage or child rearing. And it so disturbed me that this was what the Supreme Court had to say about LGBT people that I decided that I wanted to work in LGBT rights, which was what led me eventually to law school.
I actually remember reading Bowers in law school and having a very similar response to it. And unfortunately, reading it in a class where the professor did not do a very good job of leading the conversation. So there were lots of sort of homophobic things that were thrown around as part of that discussion. But that's definitely one of those cases that is such a bedrock of how we think about LGBT rights in the law and how far, in many ways, I hope we've come. Although there's obviously still places to go. So you went to law school because you wanted to be an advocate for LGBT folks. And then what did you do when you graduated?
So when I graduated, I clerked for a year, and then I was lucky enough to get a public interest fellowship to work in LGBT employment rights. So I was funded by the Skadden Foundation to work at an organization that was then known as the Center for Lesbian and Gay Civil Rights in Philadelphia. And they were an unusual organization in that they were sort of a hybrid between an impact model and a direct legal services model. So they did a lot of work for low-income people doing, sort of direct services type work, but then they also brought impact cases. And so I was fortunate to have a practice that combined both in the employment sphere. So I was both helping people with trying to enforce the Philadelphia Ordinance, which explicitly provided LGBT protections by writing angry lawyer letters. But then I was also litigating cases under Title VII, arguing for coverage under the sex discrimination provisions for those who didn't otherwise have coverage under local law, because Pennsylvania was and is a state where there is no explicit sexual orientation or gender identity coverage.
Right. I want to pick apart a couple of things in what you just said, both just for clarity for folks who are listening, but also because, again, I think it's really foundational for the rest of the conversation that we're going to have today. So first of all, one of the things that is, as you said, that's sort of unusual about the Center for Lesbian and Gay Civil Rights is that there was a combination of direct services work and impact litigation. So when we talk about direct services, obviously we mean, providing representation to individual people in their cases. And that's what we sort of think of as the direct services model. Often when people think about legal services, that's what we're talking about. And then impact litigation. Can you describe what you mean when you say impact litigation, or what we mean as lawyers when we talk about impact litigation?
Sure. So impact litigation, obviously you're still serving individuals, right? There's always an individual at the heart of those cases. but it also hopes to achieve not only a result for that individual, but also something that will change the legal recognition of the rights of the group within the law, right? So that's the basic idea behind impact litigation, is using these individual cases to mean that the next 100 cases don't face the same response of you're not protected, and that they have meaningful protections within the law as developed by the courts.
Perfect. So you got to do a little bit of both, which I think is actually a really great way to start a legal career. And I say that as a totally biased person because that's how I started my career as well. But I do think that it's super valuable. You also talked about litigating Title VII cases. So tell people what Title VII is and what it does.
Sure. So Title VII is the major law that people think of in terms of federal employment discrimination. It was the seminal statute enacted in 1964, primarily to prohibit race discrimination in employment, but it also prohibits sex discrimination, religious discrimination, national origin discrimination as well. And so its sex discrimination provisions in particular have long been an arena in which LGBT employees have argued for coverage of discrimination against them, and just recently have obtained some really spectacular success.
Absolutely. And maybe a little unexpected by some of us, but
Well, so I am one of the few people who all along has been optimistic. I really thought from the start here that there were very strong arguments under the textualist methodology, the idea that the statute says because of sex. The court has said that means if you're treated differently because of your sex, the outcome would be different, but for your sex, then you win. And I really hoped that there might be at least one of the textualists on the court who might be who is politically conservative, but who would see the strength of this argument. And I think that's what we saw with Justice Gorsuch. So it was, I would say, I was a little less surprised, but still extremely pleased by the result.
excellent. Well, let's walk it back a little bit and talk about the Bostock case, but also give it some broader context. Because I think one of the things that's sort of challenging for people is to understand why discrimination based on someone's sexual orientation or sexuality can be understood as sex discrimination. And obviously, some of the early same-sex marriage cases were based, right, on the idea of sex discrimination. And so it's not as if this is some sort of new argument that's floating out in the world, but it seems to be confusing to some people. So maybe you could sort of, help people understand how
Sure.
discriminating against somebody on that basis is discrimination on the basis of sex.
Yeah. And people should not feel alone. This concept also confused many federal judges for many years.
Yeah.
So but the basic concept is actually fairly straightforward. And I think once you understand it, it's hard to see it any other way, right? So the idea is in our federal anti discrimination statutes, if the adverse outcome would not have happened to you if you were outside the protected class, then that is discrimination, in this case, because of sex. If you consider the circumstance where a woman is fired because she's a lesbian, the very same conduct that the employer is objecting to, say her dating a woman, is conduct that they would find entirely unobjectionable in a male employee. So in that circumstance, the outcome would be different if she were a man. And so that's the basic logic. So too, if we're talking about a transgender employee, in that circumstance also, the adverse experience, say a termination, would not have happened but for the sex that the employer identifies them as having, right? So if you have a transgender woman in the workplace and the employer fires them because they plan to show up wearing traditionally feminine attire, that is something that the employer would not object to and presumably would not terminate someone for if that individual had been assigned the female sex at birth. So in both circumstances, it is the employer's perception of the employee's sex that makes a difference in the outcome there.
Right. And, when you explain it, as you say, it's really difficult to understand how someone couldn't understand that. And yet it took until 2020 in the Bostock case for this to be something that went up to the Supreme Court, where the Supreme Court articulated the view that you've just shared with us. So can we wind our way a little bit through the history here and the litigation that ultimately led us to where we are today, which was the win in Bostock?
Sure. And I think this is such an essential point for any type of civil rights or social change litigation. I think people often only hear about the final decision by the Supreme Court, and they sort of assume it springs fully formed from the law in some objective sense. But typically, when you see a big decision like this, it's because of the groundwork that's been laid over decades to allow the courts to see the logic of the opinion. Because, of course, judges come in with their own biases.
Sure.
And to the extent those biases cause them to see the world in a particular way, they may not be able to be receptive to a legal argument, even if it is, in theory, a strong one.
Definitely.
In this particular case, arguments for why anti LGBT discrimination should be considered sex discrimination have long existed. So, some of the earliest cases brought under Title VII actually involved transgender and gay employees seeking protections under the sex discrimination provisions. At that time, LGBT status was extraordinarily stigmatized. Courts considered this a completely implausible idea that Title VII might be construed to prohibit discrimination against LGBT people, and typically turned to what they assumed congressional intent to be, which was an intent to exclude LGBT people. That all started to shift for a couple of reasons. You mentioned some of the early same sex marriage litigation, which was important in this regard. I would say even more important in the employment context was a decision called Price Waterhouse versus Hopkins, which was decided in 1989, and in which the court recognized that discrimination against an individual because of their failure to conform to gender stereotypes is a form of sex discrimination. So the woman in that case was going up for partnership at PricewaterhouseCoopers. She was, by all accounts, an excellent employee, bringing in major clients, doing excellent work, but she was also not traditionally feminine. And so the advice given to her was, if you want to get partnership next year, you need to walk more femininely, talk more femininely, wear makeup, wear jewelry, etc. And this was the advice given to her by her supporters, right?
Right.
People who wanted her to succeed. And that opinion, particularly with respect to transgender employees, courts just were able to see how, if you can't say that to a woman in this context, this logic also extends to those who want to terminate a transgender employee for what they perceive as gender nonconforming conduct in a different context. So
Right.
they were unwilling to carve transgender employees out of the protections of Price Waterhouse, which is what you would have to do to get around that logic.
Right.
Sexual orientation took a lot longer. I think that the EEOC here deserves a lot of credit. Both your Codeine, David Lopez, and in particular, Hai Feldblum really advocated from within the agency for this straightforward logic as to why sexual orientation discrimination is also sex discrimination. But that was something that took the courts much longer to see.
Right. And there's so many interesting pieces to these kinds of cases, right? I mean, so one of those pieces is as a case or as, an issue is continually winding its way through the courts and different cases are being filed, there are also just changes going on in the world. So I think one of the things that's interesting to think about, and I'm curious what your response would be to this, is whether the foundation that's been laid by marriage equality and just sort of the shifts in public opinion and public perception about LGBTQ folks is part of how we could get to where we are today in terms of the decision in Bostock. I know that there's this claim that the Supreme Court is insulated from the world, right? And they're just focused on the Constitution. But I wonder if you think that Bostock could have happened, say, before the marriage equality cases.
So I 100% agree that shifts in public opinion around LGBT folks has been tremendously important, and that we probably could not have seen the outcome in Bostock without it. And I think the evidence of that is the initial response of the lower federal courts to these types of claims. Again, during an era when LGBT identity was heavily stigmatized, subject to legal discrimination by the federal government in all these domains, I think it just struck judges as completely implausible that there might be restrictions on the ability of employers to discriminate against their LGBT employees. So I absolutely think that the ability of courts to see the logic of strong legal arguments depends to a very significant degree on whether the social circumstances are receptive to it. And there's plenty of other examples of that as well, of arguments that failed in a time when judges were not prepared to see them and are essentially the same argument that succeeds sometime later. The marriage context itself is a great example of that. The Supreme Court rejected that argument as basically spurious, not even raising a federal question in the 1970s. And then some decades later, on the same reasoning, realized that this is indeed something that is within the logic of what the Constitution requires.
Let's talk a little bit more broadly about the Constitution and constitutionalism and some of your scholarship. One of the things that was really wonderful for us institutionally is that we did, as you sort of suggested, have both David Lopez, my co-dean, who was a huge part of laying the groundwork for Bostock, but your work also laid the groundwork for the decision that was made in Bostock. So tell us a little bit about what part of your scholarship was relevant here and how it was useful to the court in making its decision.
Sure. So I had written an article shortly before these cases went up to the court called Statutory, Originalism, and LGBT Rights, in which I really focused in on the straightforward textual argument that we talked through, right? Just looking at, would the employee have been treated in the same way if the employer perceived their sex differently? And that in each and every case of anti-LGBTQ discrimination, the answer is no, they would have been treated differently. And that article also took on some of the quasi-originalist arguments that were being made in the lower courts, where essentially litigants and judges were attempting to get around the fact that we no longer use congressional intent as a way of sort of carving out applications that are within text. So with the rise of textualism, that's really fallen out of favor to say, well, we don't think Congress meant this, so we're just going to pick this group out and say they're not going to be entitled to these rights. So a number of litigants in lower courts had shifted that discourse to say, well, but the original public wouldn't have anticipated these either, and had treated that as if it were some sort of a novel, distinctive, and permissible argument as a matter of textualism. And I made a variety of arguments for why that was not the case. And I know because the ACLU attorneys have told me that that article was very influential in their briefing to the court. I also submitted an amicus brief co-authored with the Constitutional Accountability Center, in which I made similar arguments. Of course, the textualist arguments were not entirely unique to me. Other people saw them, other people made them. But there was one particular part of the decision when I reached it that was just this moment of, oh my God, this completely came from my article. This argument about how the public didn't imagine this argument could lead to the exclusion of disfavored groups. And they're talking about prisoner rights. In this case, Yeski, Yeski is a case in which Justice Scalia said the ADA applies to prisons, even though no doubt people would not have anticipated that. They probably would have even opposed it, right? The idea that we're giving prisoners this massive bundle of rights in the context of disability. And that's not something, as far as I know, that anybody has argued except for in my article. So that was really a pretty amazing moment to see that in the opinion. And I think it's a really powerful passage in the opinion about why we need to be careful in how we think about who can be excluded from otherwise existing rights based on our assumptions about whether or not people would have thought they were covered.
Right. And of course, I mean, that goes back to one of the great debates in thinking about how we interpret the Constitution, right? And whether we think of the Constitution as static or as more of a living document. And that kind of leads me to another piece of the conversation. So first of all, actually, let me go back and just say congratulations, right? It's an amazing thing in an academic career to have the US Supreme Court rely on your thinking in large part in order to make a decision that is literally transformative for thousands and thousands of folks in this country going forward. So that's a feather in your cap that nobody ever gets to take away. So that's really wonderful. So one of the things that I think is really fascinating both about kind of this work but also some of the other work that you do is on one hand, and we've seen this after Bostock, people sort of saying this is judicial activism and this is the court, creating rights out of nowhere, which is a critique that people like to lob whenever there are decisions that actually create parity and equality
Right.
as opposed to new rights. But what I think is really interesting and in some ways radical, I think, about your work is that it says, here you've already set the rules, right? The rules exist, and all I'm asking you to do is apply those rules as they exist, right? We're not trying to create some sort of new way of interpreting the Constitution or interpreting a statute, right? In this case, we're doing
Mhm.
it in the way that we've been told we're supposed to do it. And so the other piece of that, I think, jumping into some of your other work, is the work that you've done about rational basis review. And certainly there are those of us, and I include myself in this category, who have argued and continue to argue about the importance of having, the highest standard of review for discrimination against LGBT people, or the highest standard of review for X, Y, or Z thing. And you've made it really clear that that's not necessary in lots of cases, and that it can be really powerful to use a standard of review that we've often thought of as being so easy for discriminators to win under, and have said actually there's some real power in that. So can you walk through that part of your scholarship?
Sure. So, for those who weren't educated in a law school, for those who aren't lawyers, the sort of backdrop here is that the stereotype about rational basis review, which is the sort of default standard, everybody gets it. If you don't qualify for some higher level of review, it's the default that you get in raising equality claims and claims under the Due Process Clause. And the sort of stereotype about it is it's completely ultra deferential. No one can ever win. It's useless. If you're a group that's stuck with it, essentially, you're going to lose and you're always going to lose. And to be clear, that is an accurate representation of one branch of rational basis review. So there are cases in which the Supreme Court has laid out standards under which it would be literally impossible to win. So things like real reasons don't matter. So the government can come up with any half cocked, made up after the fact reason why it acted. And evidence doesn't matter either, right? So, under those standards, you can easily see how essentially anything a government wants to do, it can find a way to justify it. The problem with that account, and the problem with teaching young lawyers that that is the truth of rational basis review, is that in practice, neither the Supreme Court nor the lower and certainly state courts consistently apply that version of rational basis review. Rather, it's the case that there are innumerable contexts in which social movements have succeeded in the past and are currently succeeding today in raising these types of rational basis claims. So the initial context that actually got me interested in this was learning about the early sex discrimination cases before the Supreme Court, which today are sort of taught as this straight shot to strict scrutiny or to intermediate scrutiny by many con law professors, but which really started out as the court thinking it was applying rational basis review and saying, we just don't find these distinctions based on sex to even be rational. And that helped to pave the way for sort of undermining this set of beliefs about sex discrimination, about why it was justified, that then allowed the court to say, as a matter of course, this receives heightened review. So, in some ways, it's an example of the type of dynamic we were talking about earlier of how it's so critical to shift these background beliefs, but doing it through the courts and more directly engaging judges in this project of seeing why certain types of discrimination are irrational.
Excellent. One of the things, though, that you talked about earlier was the fact that Pennsylvania does not have a statute that specifically protects LGBT people from discrimination in employment, which is true in many states. Half the states, is that right?
Yeah,
Is
roughly
that
half
number
the
somewhere?
half the states.
Yeah, roughly half the states do not have state law that protects LGBT people from employment discrimination, and which I think a lot of people unfortunately don't know, right? I mean, I think part of what happened after marriage equality was this sense of, oh, look at that, we fixed everything. And yet there continue to be these gaping holes. And so, can you explain for folks what it means that we now have this Supreme Court opinion about Title VII for people who live in states where there is no state statute that protects them from employment discrimination based on sexual orientation or gender identity?
So that I think is such a critical issue. I think that many people aren't aware of the scope of anti-LGBTQ employment discrimination that continues to take place in this country. Transgender people in particular face astoundingly high levels of employment discrimination. Those who are both LGBTQ and minorities also face very, very high rates of employment discrimination. And while sometimes there were possibilities about how to raise claims, even in states like Pennsylvania, right? I was a lawyer there. I wasn't doing nothing. There were local ordinances. You could try to make arguments that it was covered as sex discrimination under state law or under Title VII. But sometimes at the end of the day, a judge would say this simply isn't covered and the person would be out of luck. More importantly, I think from my perspective, the lack of clear protections really incentivized employers to not take anti-LGBTQ discrimination and harassment seriously. So I had cases involving clients who were subjected just to horrific forms of harassment and discrimination, having hot lead thrown at them,
Oh,
throwing up every day on their way to work because they were so worried about going to work. And they reported it to their employers, the type of things that you would hope that employers would address no matter what the reason they're being perpetrated on an employee. But the reality is that without the incentive of the law, often employers don't. So what Bostock means is now there are those incentives everywhere in the United States, right? Employers will now understand that anti-LGBTQ discrimination and harassment are unlawful and that they will potentially face liability as a result if they don't take steps to address discrimination and harassment within their workplaces.
and that's really powerful, as you say, right? I mean, I think that it's powerful both in the sense of providing a remedy for people who are individually treated in these abhorrent ways, but it's also powerful in terms of the message that it sends more broadly about, the value of the lives of LGBTQ people. So, in terms of what the future looks like, as we look at the landscape of LGBTQ rights and advocacy and impact litigation, so we have this really great decision about employment discrimination. Do you have a sense of what you think is kind of the next frontier here?
So I'll say a few things. I mean, I think that what I think of as finishing the unfinished business of Bostock is
Hmm.
definitely going to be one of the next set of battles to be fought out. So, Bostock, the reasoning of Bostock quite clearly should extend to many of the other areas of federal and state anti discrimination law that have similar prohibitions on discrimination because of sex, that use similar causation language. So, statutes like Title IX, the Fair Housing Act, and the like, Bostock should be fairly predictably extended to those contexts. But I think we're going to see a fair amount of litigation over those issues, as well as litigation over a set of issues that the court left explicitly open in Bostock around transgender individuals' access to gender identity appropriate facilities and
Mm.
the ways in which religious exemptions will or will not be permitted to undermine discrimination claims. So I think all of that is on the horizon. What I also hope will be on the horizon is LGBTQ organizations thinking seriously in concert with other rights groups about how to ensure that the protections that they've won are meaningful. Because, of course, the fact that we have sort of comprehensive race anti discrimination protections does not mean that people don't experience race discrimination. Absurd to think that that has solved our problems of race discrimination. And so that's a project that I really hope that the LGBT rights community dives into with both feet, because it is important both to their own communities, but also to any of those communities that are nominally supposed to have anti-discrimination rights under federal law.
Right. Yeah, I mean, so one of the things that I think can sometimes be demoralizing is, to have these big victories and then remember, oh, there's so much more left to do.
Yeah.
And yet it is really important to celebrate when we have these moments that are, really breakthrough moments and that will have significant positive impacts on lots of people's lives, even though there are still all of these steps that we have to go through.
Yeah.
Can we talk a little bit about, there are obviously people who are just sort of Supreme Court watchers, right? And they just, every case that goes up, they want to know, what are the justices going to do, and, anticipating where people are going to fall. That has become its own sort of genre of being a scholar. So there were lots of concerns about this court and how it's composed now, particularly after Justice Kennedy retired. What's your sense of where you think this court sits, which is sort of a weird question to ask. But I think what I'm trying to get at is, there are definitely times when the Supreme Court has been thought of, oh, this is a liberal court versus this is a more conservative court. And it seems like we're in a really complicated space now. And I wonder if you feel the same way.
I completely agree with that. I think, first of all, Justice Kennedy was less of a swing justice than in some senses people conceptualized him as, right? So he was pretty consistently pro LGBT. In certainly in the constitutional context, I wouldn't have characterized him as a swing justice there. But he was also consistently quite conservative in most of the race cases. So,
Yeah.
He swung on some issues, but not on others. And with respect to the current court, it's interesting. I definitely see both what I perceive as unusual glimmers of hope and reasons for concern, right?
Yeah.
I think it, as you say, it is a very complicated landscape on the court right now. And the justices that have been appointed under the Trump administration, I think, are proving to be not so consistently ideologically conservative as many people expected. Bostock is certainly a great example of that. There was another decision earlier this term about whether non-unanimous jury requirements are constitutional. So the idea that you could have somebody convicted even with a non-unanimous jury, is that constitutional? And that case also I found very striking. It was a case dealing with a set of laws that had been put in place explicitly for racially discriminatory reasons, right? So that if you had the one African American or the one Latino on the jury, they couldn't essentially vote for acquittal and prevent the person from being convicted. So that was the major purpose behind these laws. But they were enacted long ago, and there are plenty of circumstances in which judges have simply essentially said it's too far removed. We won't impugn the current government with the idea that this is tainted by this past. And yet, in a decision written by one of the conservative justices, the court really takes up that history and says this is a part of our reason, a significant part of our reason for striking down these policies under the Constitution. And that was really striking to me. I don't think we've seen conservatives on the court engage with race and our history of race discrimination in those ways for certainly the time that I've been paying attention to what the Supreme Court has been doing.
So we're winding down in terms of time, but I wanted to ask you one last question. You are a constitutional law professor, and so you have the power to shape how lots of law students think about our Constitution, both as a historical document and as a present document. Can you tell me what you want your students to know or to think about the Constitution when they leave your con law class after their first year of law school?
So I think that the primary thing I hope that my students will walk away with is an understanding that, number one, the legal rules we have usually aren't the legal rules we have to have. So the Constitution speaks in these very broad and open textured terms, things like my field, right, equal protection, What does it mean to afford equal protection of the law? There are lots of ways the law could flesh that out. And I think making sure students understand that there are choices we are making when we define the law in a particular way, and that those choices have consequences, most often for the groups who are sort of on the losing end of societal biases to begin with. So that's certainly something that I hope my students take away from my class. I also think just learning that the law of the Constitution is far more complicated than the law that they're getting from their casebook. So I often supplemented my class with lower court cases, state court cases, because the reality is that the picture of the doctrine that we provide students too often is this sort of stale, static thing, when in reality, the joy of being a lawyer is there are almost always arguments to be made on either side, and that the lower and state courts often engage those arguments in ways that can be incredibly powerful on behalf of underrepresented constituencies. So that's another major feature of my class, is sort of exposing students to that side of constitutional law outside of the Supreme Court.
Right. And certainly, as somebody who also teaches a first year class, it's also just an opportunity to help students and future lawyers understand that of course, the law isn't static, but also that it's not just a series of really clear, objective rules. We can teach you those rules, and then you can apply them in any set of circumstances, as if it's a mathematical formula, right? That we are churning out lawyers who are not just interpreting the law, but who are shaping the law in really significant ways, and hopefully in ways that are meaningful to the world. Thank you so much, Katie. I mean, this was a really wonderful conversation. It's always fun to be able to talk to people about the work that they're doing. And as I said, earlier, I really admire what you do, the way that you mix legal theory and being an academic with also recognizing that we have privilege and power in these roles, and that we can use them in ways that are actually transformative of the law. So I very much appreciate you, and I'm so grateful that you are one of my colleagues.
Well, I feel very much the same about you. So it has been my delight to be on this show, and my delight to be a faculty member in your law school.
Well, thank you.
The Power of Attorney is produced by Rutgers Law School. With 2 locations, minutes from Philadelphia and New York City, Rutgers Law offers the prestige and reputation of a large, nationally known university with a personal small campus experience. Learn more by visiting law.rutgers.edu.